Hello, I'm Jason Ruiz. I'm the City Hall reporter at the Long Beach Post. Welcome to the Post debate featuring candidates for the Long Beach City Attorney. It's one of several debates that we're going to be hosting before the June 7th primary, where some citywide races could be decided in advance of the November 8th general election. For some, including head-to-head comparisons of candidates in all of the races, you can visit our elections homepage at lbpost.com/elections. There's going to be a compare your candidate tool up there in the coming days. Co-hosting with me today is our managing editor, Jeremiah Dobruck. Over the next 45 minutes or so, we'll be asking questions of the city attorney candidates. They are former council member Gerrie Schipske and current assistant city attorney Don McIntosh. Each candidate will have 2 minutes to answer the questions that we ask. When their time is down to 30 seconds, I'm going to hold up 3 fingers like this. And then when we get to 0, I'll put my whole hand up, just in case you wonder why I'm doing that. When their time is expired, the hand goes up, and we'll ask them to wrap up their thoughts so we don't have to interrupt them, as we know Zoom will cut them out if somebody speaks over them. If a candidate is attacked directly, they'll have a minute opportunity to respond. They will also have an opportunity for a 2-minute closing statement, but first they'll have a 2-minute introductory statement. So let's go ahead and go to Don, if you'd like to do that.
Great, thank you. Good morning. My name is Dawn McIntosh, and I'm running for Long Beach City Attorney. A lot of people aren't entirely clear on the responsibilities of the city attorney, which is set forth in and limited by the city charter. The city attorney is a nonpartisan legal advisor for the city. In that role, the city attorney advises every city department, board, commission, committee, and the city council. The city attorney drafts all ordinances, contracts, and other legal documents for the city. After the contracts are executed, it's a city manager's responsibility to ensure contract terms are being complied with and enforced. The city attorney handles all legal claims and civil litigation for the city, also approves the form of bonds involving the city, and handles investigations of potential civil violations of the civil charter, city charter, and other laws on behalf of the city. This is a really important and technical position. It's a very different position from the city council or the mayor. The city attorney is not a politician and doesn't set policy. I'm currently the assistant city attorney, and I've been practicing municipal law for 30 years. I know this job, and I have the experience to do this job well. I've lived in Long Beach for nearly 24 years, and I've raised my family here. I'm running for city attorney because I want to do my part to make Long Beach the best city it can be. Thank you.
Great. Gerrie?
Good morning. I'm Gerrie Schipske, and I'm a candidate for city attorney. I was born in Long Beach and have raised my family here and have spent my entire adult life trying to make things better for people to work, to live, and to retire in the city of Long Beach. I served 8 years on the city council. I also was on the Community College Board of Trustees and was vice president member of the California State Medical Board. I'm running for city attorney because I'm hearing from people everywhere in Long Beach that they want to see change, they want to see reform. I have over 32 years of legal experience, legislative experience, and administrative experience. I worked inside the city government, was the city's commercial services officer with a division of 105 people. I've worked in private enterprise and in small business. So I know what it is to be inside City Hall as well as to be the focus and target of City Hall. And I'd like to change that. I have 4 basic issues that I'm running on, and the first is important for advocacy for open government. I was the strongest advocate on the Long Beach City College as well as the Long Beach City Council for open, transparent, and accountable government. And as a consequence of that, I was honored at the White House as one of only 7 champions of change for open government because of my work. I'm also advocating for fiscal responsibility. The city of Long Beach has paid out too many claims, too many settlements. And part of that fiscal responsibility is not only the accountability to explain that, but also to engage in what I'm terming as aggressive, proactive risk management, so that we can not only assess the claims that are current, but to assess how we stop them and how we prevent them in the future. I'm also calling for neighborhood protection and preservation. We need to be very aggressive but compassionate about the issues of homelessness, and we have an opportunity to do so. So I'm open to answer any questions you might have. Thanks.
All right. And I think Jeremiah is going to start us off with the questions.
Yeah, thanks both for being here. We appreciate it. And the first question really is about how you view the role of city attorney, which we all know is to advise the city on legal issues. But as an elected official, should the city attorney be more vocal when the city council is pursuing a policy or a rule that is potentially illegal? To put that a different way, is the city attorney's obligation to protect taxpayers from legal liability that may come with council decisions, or is it to defend the city council's decisions if they're challenged in court? We'll start with Gerrie on that one.
Okay. Well, the only client the city attorney of Long Beach has is the city. And in most instances, the city attorney must give advice to the council, which is taking action that may negatively impact the city, but does so in closed session because you want to be very careful about exposing the city to litigation. That being said, historically, our city attorney has really not, I think, been as vocal as she, and this will be the first time we have a woman elected, she needs to be. In other instances with other city attorneys that are elected, they not only provide legal opinions so that the public can understand the decision-making process, but they're often a lot more vocal than has been the case in the city of Long Beach. For instance, this issue about the Measure M, I don't know what advice was given. I wasn't on city council at the time, but certainly after you have lost at the trial court level and the appellate level, I would assume that somebody should have advised the city to stop transferring the water money, because consequently now the amount that they owe the ratepayers is 30.9 million. So I think there's room in there, but certainly your client is the city on it's not individual council members or the mayor or the different departments, it's the entire city. And I think we need to take a look at this office very carefully to see how we can bring the kind of reform and openness that we need. And so that's a good question. I think it's one of the first times it's been asked about the different kind of roles of the city attorney. Thank you.
Thanks, and we'll go to Dawn next.
Thanks so much. Yeah, it's a great question. Basically, as Gerrie mentioned, the city attorney advises the city council and the boards and commissions, and the city attorney is representing the interests of the city. The city is the municipal corporation. The city council is the legislative body that is tasked with making decisions on behalf of that corporation. So the city attorney is advising the city council. Legal advice is confidential, and that privilege of the confidential advice is held by the city council, not the city attorney. So the city attorney doesn't have the right or the ability to make their advice public. It is the city council that is the holder of the privilege. And so the city council gets the city attorney's advice and then makes the decisions on behalf of the city. When the city is sued, it is the city attorney's responsibility under the charter to defend the city. And that is whether the city is sued as a city or whether a city employee is sued for their actions as a city employee. That is the city attorney's job under the charter to defend that litigation. My opponent mentioned Measure M and the fact that the city had lost at the trial court and lost at the Court of Appeal, and that they should have stopped transferring the funds. In fact, the city did stop transferring the funds after the Court of Appeal, or after the trial court decision. And they entered a stipulation with opposing counsel that, in fact, funds would just be put into an escrow account and wouldn't just be transferred over to the general fund. So no funds were actually spent from the general fund after the trial court decision. But meanwhile, a very similar case was being brought in Sacramento, challenging a very similar ballot measure in Sacramento. And that case was won by the city of Sacramento at the Court of Appeal level, where the court there found their measure was constitutional, even though our court found our measure was unconstitutional. So this is a very complex area of the law. And right now, the law is still unclear in California on that issue.
Great. I have the next question. skip around here. We will come back to Measure M, but on the topic of homelessness, which is obviously a really big issue for everyone in the city, including the people who are homeless. Do you support Governor Gavin Newsom's proposal to make it easier to force mentally ill and drug addicted people into treatment? Obviously, that legislation is going to evolve as it works its way through the legislature. But I mean, if it doesn't pass, what are some legal options the city isn't currently using to improve its response to the housing crisis could be used, in your opinion? And I think we started with Gerrie first last time, so we'll start with Don.
Great. That's a great question. Governor Newsom is proposing the care court system, which will create a whole new opportunity in a way for folks to get people who have severe mental illness the help they need. It's a very limited group of people that this would apply to, people who have schizophrenia and other mental illnesses that make it so they cannot make their own decisions. So it's not just people who are mentally capable who are suffering from some sort of mental incapacity. It's people that are truly incapable of making their own decisions. And in those instances, someone has to help those folks if they can't make the decision to help themselves. So I do support that. It would be the city prosecutor in our situation who would handle those cases. The city attorney would not be responsible for that, because these situations would arise in the criminal context when these people are cited for various violations. They could also end up in court if a family member or mental health professional decides to bring a care court action. If they think someone in their family or their neighbor is really struggling with this type of mental illness, they can bring that action. But if they did, it would be purely civil action and wouldn't involve the city. So it's a major crisis, the homeless situation. Mental health is a big part of that. Drug addiction is a big part of that. Financial incapacity is a big part of that. And we've got to deal with each of these pockets in a different way. So I think the care court situation is a good opportunity to try to get some of these folks that cannot make their own decisions some of the help they need.
But if the I just want to follow up on that. If for whatever reason it doesn't go through at the state level, in your legal opinion, is that something that the city could do, even if Sacramento?
No, I don't think the city could, on its own initiative, decide to take this action. The state would have to make this a law that gives people the authority to pursue these actions. Without that change in the law, there's not that authority at the moment.
Okay. Same question to Gerrie, and take into account the clarification.
Right. No, I do support the care court concept as a nurse practitioner and a healthcare attorney. One of the problems that's going on in Long Beach is that we do not have adequate resources for drug addiction, alcohol. I've been out there talking to people who work in the homeless area, and that's their biggest concern. They can't get people off the street because they can't take them to programs. And so one of the things we need to do in Long Beach through our health department, and by the way, we're one of 3 cities that has a health jurisdiction, is we need to focus on the needed programs that can enable people to get off the street. That being said, we also have to be sensitive. I had a press release I put out, I think a week or so ago, about the litigation that was filed against the city of LA, which just settled. And that was because business owners and others felt that the city was not doing enough to preserve private property because of what was going on in the business district. And I think we need to be very sensitive about that. We've got people down in Belmont Shore who own businesses who are very concerned that you've got homeless people camping out in front of the businesses and basically disrupting being able to attract business people down there because they don't want to walk in the area. We need to be compassionate, but we need to be aggressive. And I think with the care court system, that will allow with the most seriously ill, the schizophrenic, and those that are psychotic, to be able to be placed under conservatorship and to have those court-ordered services. But folks, if you don't have the services, we can't order people to do something locally, and that's going to be a problem. And so that's what we have to resolve, I think, first, or the problem is just going to continue.
Okay. Jeremiah.
Great. Thank you. So we are actually going to circle back to Measure M, and we'll start this time with Gerrie. But as you both talked about before, a judge recently ruled that it was unconstitutional for the city to transfer excess funds the water department collected and transfer them to the city's general fund, and that was known, that was codified in Measure M, which is why we keep referring to it as Measure M. After that ruling, the transfers ended, but the higher fees that the water department is charging remained in place. Should the water department end this practice, as it could lead to additional litigation against the city? Why is the city continuing to do that, and should that be ended? And then we'll start with Gerrie.
I'd be happy to answer that. The city currently is risking a class action suit by the water payers to have that exactly what you just said happen. The courts, and it wasn't just recently, the courts ruled at the trial level, a very, very extensive ruling, very clear that the surcharge of 12% is a tax, that it was not on the surplus, that the surpluses were supposedly created by allowing in Measure M the monies to be increased, the rates to be increased, and that the transfers were then made into the general fund, which, as we all know, under Prop 218 and Prop 26, particularly about water, you cannot assess fees and services on water that's not related to water or the water service. City tried to do this in 2016. They assessed the water pipes, its own water pipes. And again, we pushed forth that litigation and the city settled, and that was a $12 million settlement. And to make up its lost money, it said, "Oh, we have an idea. Let's put a surcharge on the water rates," and that's where Measure M came from. So now there's we don't quite understand the reluctance of not returning the entire increase and to stop the surcharge. And unfortunately, I think that's going to have to be played out again in court.
Yeah, and just so for anybody out there who hasn't been following Measure M, the water department has voted to give back $9 million so far, and
Correct.
the city is going to transfer the remainder of the balance in September, I believe, and then there'll be another vote at that time to decide what to do with that money. But as of now, not committed one way or the other.
Jason, if I can add, and the difficulty about that $9 million and $100 credit for everyone is that you've got business owners who were assessed a much higher fee increase relative to that 12% than a residential user. And they're contending now, that's going to be a whole other issue. They're contending that they're really entitled to a higher return.
Correct. I was at that meeting and some people brought up that very issue. Yeah. Dawn, would you like to do you need us to restate the question, or do you have it?
I think I've got the question.
Okay.
Yeah. So I think you're talking about Measure M and the transfer ended, but the fees were still charged. I think as a result of the final determination, the litigation, the fees are no longer being charged as a result of Measure M. I think the water department is trying to determine if they need to charge increased fees, which may be the same amount as what was being charged under Measure M, for increases in their costs that have been occurring over the last several years as a result of increases in charges during the pandemic. During the pandemic, the water department, while their costs were increasing, they didn't want to increase the charges on ratepayers because it was a pretty difficult situation for the ratepayers and it wasn't the right time. But now they're looking at having serious increases in their costs, and they are needing to make a determination of how they address those increased costs. So if the rate continues, it won't be because it's still being charged under Measure M. That is ended with the litigation. If they continue to collect this rate, it will be for other business-related costs associated with the water department. And when we get back to the original issue of this measure was put on the ballot, and it was put on the ballot as a tax, and the voters of Long Beach passed that measure and said they wanted to pay this tax to fund essential city services, to fund police officers, firefighters, paramedics, to keep their parks maintained, to keep fire stations open. This was the purpose of the ballot measure. And so that was challenged in court, and eventually a court found it unconstitutional. But as I mentioned earlier, a very similar ballot measure, which had an 11% surcharge, ours was 12%, was found to be constitutional by a different court. So this is a complex area of the law. The city council wasn't doing something they knew is illegal. There's some risk in an area where there's no court opinions trying to determine whether something is compliant with 218 or not. But they were trying to do the right thing for the city and get some funds to use for essential city services. And the taxpayers, the voters, agreed that they wanted these funds to be used. They wanted this tax and they wanted these funds to go to the services. So now those funds are not going to go to those services. So we'll just have to see where we go next.
Can I rebut on that quickly?
I actually wanted to clarify, Gerrie. I'll jump in here. Just to clarify on your opinion on the legal issue, Dawn. Do you think the water department's on firm legal footing there to keep charging these rates even under this different justification that you're talking about?
I think if the water department has increased costs, that is a basis for them to increase their rates. If the rates are basically offsetting their costs, they can't just increase the rate to anything they want. But if they have increased costs, that is the basis for them to increase their rates.
Okay, and we're going to move on to the next topic now.
Well,
we're going to start.
Can I rebut, Jeremiah? This is very important.
I think we have to move on to the next issue now, Gerrie. Sorry.
Okay.
So the next issue is about police settlements, and we're going to start with Dawn this time.
Actually, sorry.
Are you up next? Go ahead, Jason.
Yeah,
go for it.
Off of
Although there is a Measure M component to this question. Well, we're actually going to move on from Measure M, but go ahead.
Yeah,
Jason.
we're excluding Measure M, right? So in June, possibly, most likely though November, one of you is going to be the next city attorney through this election, and you're going to be in charge. But right now you're not. Dawn obviously works in the office, and Gerrie, you work in private practice right now. But I mean, what's one policy or decision that's been taken by the city other than Measure M that you would have provided different guidance on than the current city attorney has?
Well, what is very, very egregious is when the city attorney.
1 second.
We're
going first.
We're starting with Dawn on this one.
Okay. All right.
Okay. So, this is a difficult question because the city attorney is providing legal advice every single day to every single department and every board and every commission. Our office provides advice on every single day. So to say, what one thing would you provide different advice on? It is, maybe I would advise the harbor security force that they should take a different position on an ordinance than a different attorney, but both of them are perfectly legal positions. So it's a difficult question to answer. What would I do differently? The city attorney advises the council and the boards on the risks, the legal risks, and the legal situation with any decision. It's really easy for folks to say, gosh, Measure M was found to be unconstitutional, so the city attorney gave the wrong advice. Nobody has any idea what the advice was the city attorney gave because that's confidential. The city council then takes the action they take. So I can't tell you any particular issue right now that I would have taken a different legal position on than the city attorney, because the city attorney advises on risk. That's what I do. That's what every attorney in our office does. And when you see a decision or an action out there in the world, it's really easy to say, oh, the city attorney must have given the wrong advice. But that's really not how it works in an attorney advising their client. As Gerrie well knows, we're both attorneys. You advise your client, and then your client takes the action they're going to take. So, okay.
Well, I mean, just to follow up on that, I mean, if you were, again, hindsight, and especially, for us, we're not in the room. But I mean, there are some high profile, for lack of a better word, failures that have been, seen by the city in the past few years, the Queen Mary Community Hospital, to name two. So I mean, I don't know if you want to comment on those, but
I do. I'm happy to comment on those. So the Queen Mary is a great example. The Queen Mary contracts were executed years ago with an operator, and there was not the necessary oversight of that operator and how they were spending the funding. That is not the responsibility of the city attorney's office. There is a department under the city manager that oversees contracts and contract compliance, and that was their role to oversee those contracts and make sure they were complying with them. And some of that oversight did not happen. But again, that's not the role of the city attorney's office. Some people would like to think every job in the city is the role of the city attorney's office, but it's not. City auditor also could have taken a role in oversight on the Queen Mary and did not for years. So there are certain people in the city who have that as their job. It's not the city attorney's job to oversee those types of contracts after they've been executed. Community hospital was a situation where the community, okay.
Yeah. We'll give you a little bit of extra time on that one, Gerrie, since that one went over. But same question to you. Anything that you would have provided? I guess.
Yes, and this advice was publicly given. It wasn't given in closed session because there's transcripts of the council proceedings. It's when the city attorney advised, I think it was Councilman Supernow who asked the question, when could you in fact remove that 2-line phrase in the city ordinance about office holder accounts where it says you cannot use office holder accounts for political purposes. The city attorney's response, and I believe it was Amy who said this, yeah, well, that's free speech. Political fundraising is free speech. Well, let me tell you what this has done. It vitiated the Long Beach Campaign Finance Reform Act, which was passed by voters to cut back on the political fundraising of elected officials, which says if you're running for office, you can't raise money before 1 year before the election. By allowing the elected officials to raise money politically in their office holder accounts 24/7, you allow them to raise money for 4 years before the election. That was wrong advice. Should have never been put out that way. We're the only city in the state of California that allows our elected officials to use their office holder accounts for political purposes. So that was publicly given advice. There's a number of other issues, and we can go back and forth about the Queen Mary, but the bottom line with the city attorney and the Queen Mary is that Urban Commons breached its contract, and that is the city attorney issue. We talked about this last night in another forum. The State Lands Commission actually has issued a warning to the port about taking the Queen Mary because of the impact financially. So these are things that the city attorney certainly can weigh in on and should.
Great.
Thank you. We're actually going to go, and we'll go right back to Gerrie on the next topic, which is the one I was jumping ahead to. But we wanted to talk about the police department. So over the span of about it's about 6.5 years in recent years, Long Beach spent about $30 million on police-related settlements and verdicts. One of those was a case where a police officer shot a mentally ill woman to death, and the verdict ended up being $9 million in that single case. How would you advise the Long Beach Police Department to reduce its legal exposure in excessive force and shooting cases? And this is to Gerrie.
For me?
Yes.
Well, first of all, that's why we need to do proactive risk management. We need to take a look at what has been causing the misconduct and how do we prevent it, what follow-up was done after the settlements were made. And most significantly, there needs to be a firewall between the city attorney's office and the police union. Across the state of California, those that are involved with police misconduct are calling for elected officials not to take money from police unions, because we run into a risk that if in fact the city attorney's office settles a misconduct case, that the public does not trust that we settled it for the best interest, because there's a conflict there also, because the city attorney advises the Police Complaint Commission, which, by the way, then takes complaints against police officers. And last but not least, our local police union sued the city of Long Beach because the city of Long Beach was trying to release public records concerning a misconduct case. They sued us. And so to take their endorsement, to take their support, I think begs the question about being neutral in the city attorney's office.
All right, thank you, Dawn. Same question to you. How would you advise the police department to reduce their legal exposure on these cases?
Yeah, it's a great question. And, it's an ongoing issue, as you might imagine. There are lots of situations where a police officer is confronted with a situation and perhaps doesn't make the best choice. And you can say they should have different training. They perhaps are not experienced enough to be in that situation. There's a lot of ways to look at it in hindsight. And that's what the police chief's job is, to look at these situations. Our office has regular communications with the police department. And in fact, when we handle these type of cases, after we get the cases and we're working through them, we are always meeting with the police department to talk about the things we're learning from the cases and how they reflect changes that need to be made in the police department, whether that's training, whether that's more oversight and supervision, whether an officer gets perhaps a year more training before they ever get put out on a street. But these are all the things that we are constantly discussing with the police department as we get these cases. And one could say, well, you should look at those ahead of time, but that's really, not a real option. You don't ahead of time know that a particular police officer is going to act inappropriately and go counter to their training when they're put in a situation. You can try to do things to make sure they're very prepared for the situation, but you can't anticipate, gosh, we've got 20 officers here. I'm going to guess officer number 7 is going to act inappropriately. So I'm going to look at him from a risk management situation and decide I don't want to put him on the street. That's not how the real world works. So what we do in the city attorney's office, we're responsible for handling civil litigation and the claims against the city. So when we get that litigation, when we get these use of force cases, that's when we have the opportunity to really examine them and have these real conversations with the police department on things that they need to examine and change to try to reduce this liability that the city is exposed to. With respect to the police union, there are a lot of city employee unions, and every single one of them has the right to defend their employees. That's what the union does. I think Ms. Schipske herself has been endorsed by the fire union. So the police union sued the city.
Let me, and we'll, Gerrie, we're going to give you another minute, but I want to drill down a little bit further on this too, because Dawn, you're talking about a lot of after the fact defense against the city, but all the police department's policies are public. And I'm assuming the city attorney has a role in advising them on those policies and the risks in those policies. Gerrie, we'll send this to you after Dawn, but Dawn, are there any policies that need to have a proactive look taken at them that you would advise differently for the police department? I mean, for instance, the Long Beach Police Department is one of the only department in LA County that investigates officer-involved shootings in a way different than the rest of the county. They allow officers to write reports instead of interviewing them. Can you give us an example of a policy that you think needs to be looked at to be reevaluated from a risk standpoint? And we'll give you a minute for that. And then we'll go back to Gerrie to answer that and respond if she needs to.
Again, I think that what our office does is routinely works with the police department in looking at their policies, looking at things that could be better. It's not something that we are not doing and saying, you know what, we're going to let the police department figure this out on their own. We're not going to look at their policies. We're not going to sit down with them. This is something we do on a regular basis. We go over their policies. We go over the reasons for the policies. If they do a policy that's different from another law enforcement agency, that doesn't mean their policy is bad and the other one is good. They've got legitimate reasons for thinking this is an excellent way that their office should proceed, then they should proceed that way. It's not as if someone else's policy is good and ours are bad. We have situations that come up and they need to be addressed, and we need to adjust policies as the policies are reflected to be causing these problems. But a lot of times it's not so much a policy that's causing the problem as much as an officer not following the policy or not following the training. That's where our payouts generally happen, and they're not because we have poor policies. There have been policies such as the use of rubber bullets and those sorts of things where, once those things have caused some people harm, then we look at the police department and say, you really need to look at that. And they've changed those policies and eliminated some of those tactics.
Thank you. And Gerrie, we'll give you a minute on that too.
Well, I would just respond that in February, the Racial Equity and Reconciliation Report came out to the City Council, which voted unanimously to take this effort on. And one of the comments, or several of the comments of the community regarding police misconduct, was the lack of risk management and follow-up, and making certain you can look in when you do risk management, Don, you take a look at practices and the likelihood that somebody will do something based upon not only the culture of the organization, but the practices, the management, the follow-up, the discipline, all those things need to be looked at. And I find it interesting, that's exactly what community members wrote in their assessment of things to be changed in Long Beach concerning police misconduct. They also talked about the over influence of the POA and the fact that that needs to be removed, particularly when you get into the Police Complaint Commission and you get into other activities where the city attorney is involved.
And I think the way I did that, I think the next question is we're going to start with Dawn, but Jason, that question's from you.
Okay. Okay. So we, as reporters who do Public Records Act requests somewhat frequently, are aware that, sometimes public officials don't fully comply with these public records requests in the way that the law requires them to. In such a situation, if such a situation comes to your attention, what options does the city attorney have to force compliance, and will you use those powers, not just for us, the reporters, but I mean for the public makes these requests too?
Yeah, so I think it's a great question. The Public Records Act is something that I have worked on for a long, long time. Back when I was in private practice, our firm was the one that was brought in after the Bell situation. The whole Bell scandal erupted, and one of the things I spent quite a lot of time on was responding and getting the LA Times document after document after document in response to their Public Records Act request, so they could try to piece together what had been happening in Bell. And one of the things that we took our responsibility very seriously to make sure we got those documents to them so they could do their investigation and they could get the information out to the public. Ever since I've been with the city, I have pushed hard on the Public Records Act, and there are a lot of times that folks do not want to produce records because it would take a lot of time to pull them together, or they say, oh, I don't know how to search for this. But I always push hard to say, this is an important law. You have to comply. You have to fully comply. If you have the records and they're responsive and they're not privileged, you have to produce them. And so whenever I have an opportunity to push that, I do. I've talked to the person who works in the city management department who handles this for the entire city. And she's now doing more training for all the departments so that each department person who is responsible for responding has a much better understanding of their responsibility under the Act and all of the things that they have to do to make sure they're complying. So I take this very seriously, and I definitely am pushing hard to make sure every department is responding fully to the Public Records Act.
Great, Gerrie. What are your thoughts on that?
Well, the California Public Records Act is a key component of open government, and you have the legal right to access public records. I think Don touched on it a little bit. The training of the elected officials and departments is paramount, that they understand that they have to comply. I also think public education about the public's right to ask these records. We're not as helpful on our websites as other city attorneys are about the California Public Records Act, and I would open that up tremendously. I'm going to tell you a little quick story about being in the inside of city government. We often would, as council people, get an email from the city attorney's office saying that there had been a request for records. And the question was just put to us, do you have anything on your computer? Well, that assumes everybody is going to be truthful and everybody is going to do a thorough search, but there's no thorough search of elected officials' emails and other communications. So you say you don't have them, there's no way to indicate that you don't have them. And I will tell you, I was deposed about 2 years ago. Some citizens sued on a broken sidewalk. And what the city attorney's office said in the deposition was that there were no public records of any inventory that had been done on sidewalks in the 5th Council District, which I take exception to because I had copies of it, but also I personally had walked this district 3 times with the public. So when you talk about public records, it's all, there's some nuances that go on that are not in the best interest of the public.
Okay.
Thank you. And we have a couple individual questions here. Actually, we're going to start with Gerrie on this one. So this is kind of a personal one, but you've been a vocal critic of City Hall since leaving office as a council member.
Right.
And a few months ago, you were running for mayor.
Right.
Why should the voters trust that you're going to give an unbiased legal opinion on issues you might disagree with politically?
Because that's why people asked me not to run for mayor and to run for city attorney. They felt that What I had done over the period of time, not only on council, but after council, was to be open and transparent and push for accountability. They felt that I could do this much, much more in the city attorney's office than perhaps in a ceremonial office of the mayor. So that's the purpose. And I hear this all the time, Jeremiah. I have people walking up and stopping saying, can I have a sign? You know, I really like how you've stood up and you've asked questions and you've asked for accountability. And I think that's why voters can trust what I'm going to do.
And Dawn, again, this kind of goes to you as a person, maybe a little bit, but and also looking back at the city attorney's office and its track record over the last few years, and we've seen publicly, we've seen some failures in contracts like the Queen Marian Community Hospital, and then obviously big verdicts like Measure M. But we don't get to see the advice you're giving or the city attorney's office is giving behind the scenes. So we don't know whether it's a failure of the advice that was given or if it was the council choosing to go against that advice. But without us having insight into that knowledge, why should voters trust that you're able to stand up to the political desires that the council may have and give good, strong advice that's going to say you shouldn't do this if you need to do that?
Yeah. Basically, this is what I've been doing my entire career. I have worked for 30 years representing cities and government agencies. I spent most of that time in private practice, and we were brought into situations that were complex, difficult, politically sensitive, because we had the expertise and we needed to bring the council along and educate them and get them to understand the parameters of the law, the limitations of the law. Sometimes we told them things they really didn't want to hear. And we told them, it's too bad, this is what the law is. Of course, you say that in a way that's diplomatic, but that's the kind of work I've been doing for my whole career. Generally, when you have an appointed city attorney, which most cities attorneys are, and they have a city council that is in charge of whether they're hired or fired, they don't want to give the bad advice. So they would hire my firm to come in and be the ones to have those difficult conversations with the council and take them legally where they actually needed to go. So that's what I have done my whole career. That's what I've done since I got into the city attorney's office, and that's what I will continue to do. And one of the wonderful parts about this being an elected option or elected office is that you have the autonomy to have the strength to give that advice. I can't speak to my predecessors over the last 50, 70 years, but I can tell you that as city attorney, I will absolutely be giving my absolute best advice, and I will not be swayed by the fact that city council members are also elected. That's why I'm going to be elected, so that I can give that independent advice.
Great. So I think we're on time right now to start wrapping up. I believe who do we start with first in the intros, Jeremiah? I forget.
I think I don't remember who gave.
I think I did. Yeah.
Okay. So let's start with Gerrie then on your closing statement. You know, kind of just wrap up, remind everybody why you're running and all that good stuff.
Right. I want to thank you guys, first of all, for doing this. This is very important. And in this time of still COVID, it's important that people can access this kind of interaction via Zoom. So thank you. I appreciate that. As I indicated, my name is Jerrie Schipske. I'm asking for your vote for city attorney. I'm asking you to confirm what you've been telling me as I'm out there talking with voters, that you want reform. The taxpayers are tired of being called the piggy bank to fund one failed project after another. They want to see accountability. They also want to see that their voice matters down at City Hall, and currently they don't feel it does. They do feel that they're being overwhelmed by special interests and the constant influx of political contributions that now can go on forever. I have three major things that I want to focus on, and again, it is government being open, transparent, and accountable. I want fiscal responsibility. I have pledged to roll back the $319,000 salary for the city attorney to the level of other elected officials, and to use that money to fund a neighborhood preservation program where we can work with neighborhoods on quality of life issues. I also want proactive, aggressive risk management. I think we need to do what major corporations do with enterprise risk management. We need to be proactive. We need to change things. We need to educate people. We need to make certain that the system works for everybody in the city of Long Beach, because after all, the city attorney represents the entire city.
Great. Don?
Thanks so much. Again, I want to thank you all for doing this, and I want to thank all of the folks watching this broadcast. You know, it's really important that the folks out there really get to know their candidates for election. It's an important election, so thank you again for doing this. The city attorney is an incredibly complicated and demanding job. Legal issues flood the city attorney's office every single day on a broad range of topics, from municipal governance to Tidelands, where we act as trustee for the state of California, where we represent the Port of Long Beach, the second largest port in North America. We have our own oil and gas resources. We have our own city-run utilities. The city has its own airport, and it's one of the only cities in the state with its own health department. The city attorney's office also handles all civil litigation for the city and the workers' compensation issues for the city. In this job, legal experience really matters, and the person who is taking over this job has to have the experience and the ability to do this job on day one. As noted earlier, I've practiced municipal law for cities and government agencies for my entire 30-year career. I've worked in the federal government in private practice, and I've been with the city attorney's office for the last 6 years, currently as the assistant city attorney. I'm an experienced trial attorney. I've handled cases in state and federal courts, including one case that I won that went to the US Supreme Court. In 2016, I was named one of the top women attorneys in California. I am the only candidate in this race that has the necessary experience to do this really important job. That's why I've been endorsed by Charlie Parkin, the current city attorney, as well as the 3 prior city attorneys before him. And that's John Calhoun, Bob Shannon, and the Honorable Robert Parkin. I've also been endorsed by the current president of the Long Beach Bar Association and the prior 2 presidents before her. I've been endorsed by Senator Lena Gonzalez, Assemblymember Patrick O'Donnell, Mayor Garcia, 7 of the 9 council members, and the other 2 are not endorsing any candidate. The election's on June 7th, and I ask for your vote. Thank you so much.
Great. And like Don mentioned, the election is on June 7th. We're going to be just as busy as the candidates are going to be over the next few months. We do want to thank Don and Gerrie for joining us for this forum today to discuss, some of the important issues facing the city. For any other, if you didn't have enough of this and you want to see more debates, you can go to lbpost.com/elections, where we've been keeping track of all the upcoming debates that are being held by neighborhood associations and different business associations throughout the city. We will be posting this video, so you can watch this one over and over again if you'd like. We'll also be posting our Compare Your Candidates tool, where you can, with this particular race, it's a little bit easier where there's only 2, but some of the races there's 7, 8 people running, and you can compare how they answered questions that we posted them from both our our editorial questions and questions we got from the community. We have a few more of these coming up, so we will we're going to be busy, but for Jeremiah and me, Jason Ruiz, Jeremiah Dobruck, and the rest of the LB Post team, thanks guys for joining us, and we'll see you out in the community.
Thanks so much for having us.
Thank you.